Welcome to the Case Autopsy, the Verdict and Settlement podcast. Case Autopsy is part of the family of podcasts brought to you by Lawyer Minds. In this podcast, we explore recent verdicts and settlements from around the country to try and distill down the best techniques for you to apply in your cases. Here's your hosts, Mike Campbell and Chris Finney.
Chris, my brother, how you doing, man?
Good, Mike. How are you?
I'm good. We've had some trials, I think, since our last pod, and hopefully we're going to hop on one of these and talk about my loss and your wins.
Yeah, I wouldn't call my wins, and I wouldn't call them your losses. My case was a lot easier than yours. But anyways, we hadn't been able to connect either over the last week or two. We've been kind of missing each other, so. Yeah. Glad we can get on here and then add Matt Sharp on, who this, we've done a decent number of podcasts, a lot of people to listen to podcasts. I think that people are going to find this one pretty interesting, especially with his approach and some things about what they did with the case and framed the issues, which is I think is going to be a good takeaway for everybody.
He's a great lawyer. I would definitely implore anyone who's listening in to stick through the whole podcast, listen to all the, strategies and advice he has to impart, for sure.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. Here's your hosts, Mike Campbell and Chris Finney.
Matt, good to see you. How are things going?
Nice to see you guys. Things are going great here in Reno.
Perfect. Could you tell our listeners a little bit about your practice?
Yeah, my practice is it's all plaintiffs, of course, primarily insurance bad faith with other kind of catastrophic injury, more complex type cases.
And when you say insurance bad faith, you are one of the guys there that has a pretty sizable verdict. Could you tell us something about that case?
Yeah, sure. So, I tried a case with Doug Terry, who's a lawyer in Oklahoma, and it was against United Healthcare subsidiary called Sierra Health and Life, and involved a cancer treatment called proton beam therapy. And our client, decedent Bill Eskew, needed proton beam therapy to treat lung cancer. And Sierra Health and Life, by virtue of policies that United Healthcare established, automatically denied Bill's claim and any other claim for proton beam therapy without consideration of the insurance policy, without consideration of the duty to investigate, and that was a course of conduct. And so basically Bill's life-changing decisions were made in 12 minutes by a doctor being paid $200 an hour to automatically deny claims.
And this is like when you say a doctor to review these claims, what I'm envisioning, Matt, is like those, I don't want to say doctor deaths, but apparently that was kind of appropriate in this case. A doctor in their basement or at their home getting claims sent to them and them clicking through them and saying whether it's related or not, or medically necessary, those types of things.
Yeah. It was even more insidious than that, because what United Healthcare does is they adopt these, what they call corporate medical policies that say whether or not a certain procedure is not medically necessary. So corporate bureaucrats at United Healthcare decided virtually any claim for proton beam therapy would be automatically denied. To facilitate that denial, United Healthcare hired a guy by the name of Dr. Ahmad, who was paid $200 an hour to deny claims pursuant to the corporate policy. So, we've all done, personal injury for a number of years. When was the last time you ever heard of an expert charging $200 an hour, let alone a doctor?
Yeah.
An oncologist, no less. It's crazy.
Yep.
So that was the system they used. And so in our case, and what was crazy is they had this procedure. It came out pretty clear. The procedure was They had it all set up. So if an ICD-9 code comes in, that's the coding that the doctors use for your bill.
Yep.
So a pre-authorization request goes in and the ICD-9 code matches proton beam therapy. The claim literally goes to this denial team. And the nurse.
Well, let me ask you this, like,
yeah.
The denial team, so it gets like flagged in the system.
Yeah.
Over to, you call it a denial team. Is that literally a team that's already dealing with denials from the get-go?
Yes. They called themselves the adverse benefit determination team.
I was gonna, there's probably a more of a euphemistic term, but the adverse benefit determination team, which I mean, gotta be kidding me. But so that team then looks at this proton beam therapy, I guess, prescription recommendation by the oncologist who's treating your client.
Yeah.
And who do they consist of?
So the proton beam therapy is a radiation therapy. And so it's actually recommended by a radiation oncologist. So the first thing that happens is the claim goes into this team, if you will. A nurse looks at the ICD-9 code and says it's proton beam therapy. She then looks at the corporate policy, and the corporate policy says the claim's going to be denied. So the nurse automatically refers the claim to Dr. Ahmad, who then gets an email and says, I'm going to compare proton beam therapy to the corporate policy. It's denied. Nobody ever reads or considers the actual recommendation by the treating physician. It's not part of the equation. Nobody actually considers the terms of the insurance policy. I mean, I've been doing bad faith work for a long time, and I've never heard of an insurance company literally admitting and setting up a policy that the terms of your own contract are not even considered. So in this case, we had the treating physician was a radiation oncologist from MD Anderson, by everyone's account, probably the foremost expert in the world on radiation oncology for lung cancer.
And this is in Texas. He's in Texas.
Yeah, she's in Texas.
She's in Texas.
And she's this incredibly gifted doctor who also specializes in proton beam therapy. She makes the decision.
What's Dr. Ahmad's specialty, if he has one?
Well, he was an oncologist. He didn't even know anything about radiation oncology. I mean, it's two totally different. It's like asking a pain management doctor to comment upon orthopedic surgery. I mean, they're totally different specialties. And so he knew nothing about radiation and knew nothing about proton beam therapy. Didn't matter, though, because the corporate policy said deny. So we're going to deny. But the reality was this doctor from MD Anderson, her name was Dr. Liao, she did an extensive study to compare proton beam therapy versus other alternative radiation. So this is something I learned in this case. I didn't know. Any type of radiation is effective in killing cancer. The problem is it's also effective in killing everything else.
Collateral damage.
Yeah. And that's a big issue. So proton beam therapies use protons. It's a much finer particle than what the typical therapy is, which is X-ray based. And so it uses a very fine particle that targets the tumor directly, and they can control how much of the proton goes into the tumor, so it prevents or it minimizes damage to adjacent structures, and it's much less side effects.
So kind of like rifle shot versus shotgun shot.
Exactly, and that's exactly how our expert explained it.
Got it.
And so what happened in Bill's case, he had a tumor that was, one of his tumors was near his esophagus. And so the studies that were done at MD Anderson said we can drastically limit the exposure to damage to your esophagus if you use proton beam therapy. I don't remember exactly now. I think it was a 15 times lower risk using proton beam therapy. And the problem, of course, if you damage the esophagus, you can't eat. I mean, so it's like it's of course a big deal. It's an organ. It's a big deal. And so what this doctor had done is she had really done the study to demonstrate that the risk of life-altering damage to Bill by using proton beam therapy was significantly less, and the insurance company never even considered it. I mean,
so what's sticking out to me as you go through this is Bill has lung cancer, right?
Yes.
It sounds like it has spread from his lungs to other parts of his body.
Yeah, it was stage 4 metastatic.
So he's in bad shape.
He's in bad shape.
So this wasn't a case about survivability. It's more about the enjoyment of his last years, or how would you frame in the damages on that?
Well, interesting you say that. This is another thing I learned is the advancements are such in cancer now that depending on the extent of metastasis, stage 4 is not a death sentence, even in lung cancer. And so what Dr. Liao had determined is he can survive, or at least, beyond 5 years, which is, of course, your survival rate.
Well, and who knows what happens in 5 years?
But her goal was curative, and she put that into her medical records that were sent to the insurance company, and they didn't even pay attention to that. So the goal was curative. It ended up not being curative. I mean, he ended up getting the alternative form of radiation. I mean, we kind of go through the case, but the initial recommendation was do proton beam therapy. It's much safer, and it's gonna be effective.
So his treating radiation oncologist is a leader in the country, or maybe the world, for this. She works at MD Anderson. She says from the outset, I think I can save his life with proton beam therapy. She sends that to the insurance company for authorization for the proton beam therapy, and they don't even really look at it. They put it right in the pile because they have a policy. We don't pay for these.
They conducted no investigation. So those of you that do insurance bad faith know that the key issue is the reasonableness of the investigation. You can't deny a claim in good faith if you don't do an investigation.
Mm-hmm.
Did you ever get to the reason why they denied the PBT? Is it the cost?
Yeah, that was basically it. It's basically it's a conscious decision by the company to say, well, the alternative therapy is called IMRT. And they say, well, both IMRT and proton beam therapy kill the cancer. And so therefore, IMRT is cheaper. We'll just approve IMRT. Now, what they don't do is say, okay, but what's the risk to the collateral damage? What's the health and safety issue to your insured? And interestingly, we proved that within the documents they used to create this corporate policy, there were studies that even United Healthcare cited to that if you use proton beam therapy versus IMRT for lung cancer, the risk of grade 3 esophagitis is something like, I want to say 8 times more using IMRT. And that's the key. So there's different grades of esophagitis. It's just like a burn. It's 1, 2, 3, and 4. And so what happens when you hit to grade 3 is it's life-threatening because you can't eat, you can't swallow, you can't thrive. So they made that conscious decision, like across the board. We don't care what your physician says. We're going to deny your claim automatically. And what we proved at trial was that the denial probably took no more than about 12 and a half minutes.
How'd you
the reason why we can
emails? Yeah, you have email stamps, I guess, time stamps.
Well, no, what happened was the email stamps were funny because the doctor kept citing to the wrong medical policy, and they kept having to tell him cite to the right medical policy. But the weirdest thing, I mean, think about this. In this day and age of computer, safety and everything like this, United Healthcare was letting Dr. Ahmad access their system through like a Yahoo email account. I mean, so the whole thing was shady. I mean, who does that, right? And they claimed they had no footprint in their system that could tell us when Dr. Ahmad logged into the system and when he logged out. They say, oh, we don't have that. And so then we said, well, what are your time records? Oh, we don't keep time records. I mean, we know how insurance companies are. Really, they're not keeping any records.
Right.
So what we ended up finding,
the straight face on that one, he's like,
oh yeah. I mean, and then so what we ended up finding is they do what's called batch billing. So they would send Ahmad like, a bunch of claims in a day, and he would deny all those claims, and then he would bill for like I can't remember the time frame, but he would say he would bill 20 minutes, a half hour for 12 claim denials. So whatever he denied in that thing, we divided it back out and figured he took 12 and a half minutes per claim to deny them. I mean, he claimed he went on longer, but interestingly, he maintains no records of his review, none. And the only time the testimony was, the only time his decision is questioned is if he overrules the corporate medical policy.
Oh.
Yeah, so how many times are you going to overrule the corporate medical policy, right?
Yeah. Why create more work? I mean,
exactly.
Not going to do that. So the plaintiff is Bill, and he survived by his wife, children. What do we have?
Yeah, so let me back up. I can kind of fill everything in.
Yes,
this was not a wrongful death case. It was a survival claim.
Okay.
So what ultimately happened is, the claim was denied, and Dr. Liao told the family, look, basically United Healthcare is the worst. They never changed their minds. You can file an appeal, but I'm just telling you, you're going to be fighting for him forever. And
we got to get moving. I mean, there's a time.
Yeah, he said, who am I to say that in 2 weeks I can still provide this care? He had two tumors that were growing, and one of which was near the esophagus. So the family, I mean, imagine that, like, that idea of, you have a guy he's got hope, right? He goes to MD Anderson, he has hope.
He got in with the best. Like, that's what you want, right? I'm going to get in with the best. I'm in with the best. And then some faceless person who has really no expertise just blitzed me. Like, totally took it away.
And it takes away your entire hope. And the interesting thing, too, is this was an Obamacare policy. And so the Bill's wife, her name was Sandy, she actually went out and did her research. She contacted an insurance agent and said, look, my husband's got stage 4 cancer. We want to go to MD Anderson, and we want to be evaluated for proton beam therapy. Is proton beam therapy covered? The agent gives her the form insurance policy. Sandy reads it and sees that therapeutic radiation is covered with no exceptions. So she's like, okay, we're golden.
Wow.
And and so Bill then is faced with this decision once the claim is denied. Do I fight? Or do I take this alternative treatment? I mean, the proton beam therapy for him to pay out of pocket was like $100,000. I mean, these were not wealthy people. I mean, so it was like, and the thing that I found was, like, Sierra Life knew that they were doing that, making people make those decisions. Instead of worrying about your care, you got to worry about your finances and your insurance. I mean, it's just, I can't imagine how, Bill felt making that decision, but he made the decision to go forward with IMRT. Mm-hmm. I mean, Dr. Liao is like, look, I'm good at what I do. I'm good with IMRT, but I wish I had my best tool. That's what she told the jury.
Yeah.
And so Bill goes through the IMRT, and lo and behold, he develops grade 3 esophagitis. And I didn't know, it's like the benefit of our business is we learn a lot about human human body. The downside is we learn a lot about human suffering.
Right.
And so the esophagus, it's like a burn. And so the higher the grade, the greater degree of burn. And so when that acute burn happens, it's like, you just can't eat. You can't do anything.
Swallow?
You can barely swallow. Bill lost, he lost about 15% of his body weight in about a 6-week period. So he was going down hard. They can give you pain medication that helps, which they ultimately did. And Bill kind of rallied. Surprisingly, he was a tough guy. So he was able to survive that acute phase, barely. But what happens for certain people, and it's dependent upon the grade of the esophagitis, higher the grade, the greater the risk, is it turns into a chronic problem. So the way our expert explained it, said if you can imagine how a sunburn heals, that's what's occurring in your esophagus. So what can happen is scar tissue develops, and the scar tissue, as it develops, creates a chronic problem. Mm-hmm. But it takes a while for this chronicity to show up because it occurs during the healing process. So what Bill Eskew found was goes through the acute phase, which was brutal. Then he kind of gets a little better, and then he develops a chronic esophagitis and basically is just tortured. I mean, he can't swallow consistently. He can't swallow, you can't eat. And so he can't eat consistently. And of course, everybody in the family knows if you're not eating, you're going to die. So, automatically there's like tension between Sandy and Bill had 2 children, Tyler and BJ. And so this tension develops, like, Dad, you got to eat. He don't want to eat, can't eat. And when he gets food caught in his throat and he throws up, family said that they called a puke bucket for him. And so it's just like a level of humiliation, right?
How long is that going on? Like, I mean, I know he passed away, but like from when he went to Dr. Liao, how long did he make it?
So his suffering, it was about 10 months from the point that he developed the grade 3 esophagitis until he died.
Okay.
And the testimony was from the family is that he was never the same person. Like he died in torture, in a sense. I mean, without ever being able to make peace with his, many accomplishments. So he died from the lung cancer. The esophagitis didn't help, certainly. But what we made a decision, we just made a decision and said, look, we're not going to push trying to prove a wrongful death case because you get into all the issues. Yeah. How long would he have survived anyway? We said, look, he suffered unnecessarily for 10 months of his life and didn't die on his terms. I mean, there's a value to that. How we leave. And he didn't leave in peace. I mean, and that was compelling testimony from the family. And the defense, of course, was, well, he died from the lung cancer, and the family's making all this up. The lawyer's trying to make some money. He didn't really suffer from esophagitis, all that sort of stuff. And they just didn't. I mean, the jury didn't accept it.
So how did were the Eskews, are they from Las Vegas? Because that's where you are, right?
I'm in Reno, but the Eskews are from Las Vegas. And interestingly, my co-counsel, Doug Terry, had a previous proton beam therapy case against Aetna in Oklahoma City.
Okay.
We got a very good verdict. And Sandy Eskew, what's that?
You bring Doug in, or did Sandy find him?
Sandy found Doug.
Okay.
By internet, like she was reading something about this verdict.
Yeah.
And she contacts Doug and says, I think the same thing happened to me and my husband. And so then, then Doug and I team up. and we take on United Healthcare, and the largest healthcare
Right.
company in the world. They're by far in Las Vegas. They probably have 80 to 85% of the insured market. So, I mean, they are a major player. I mean, I think most of our jurors had insurance with United Healthcare.
So,
That's how bad they were.
yeah. After that, maybe till the end of the trial. So, it sounds like this is a fairly lengthy trial. I mean, 2 weeks, 3 weeks. What was your length on
It was about it was about 3 weeks. I mean, there were dead days here and there, but I think it was about 14 days of trial.
And this is what, Harris County? Is that what it is?
Clark County.
Clark County. So you're in Clark County, 14 days of trial. Is it just you and Doug, or do you have associates? How are you guys, give us a little rundown on your setup to handle the trial schedule, stuff like that.
Yeah, so it was just Doug and I in the courtroom for us. Friedman Rubin, some lawyers from Friedman and Rubin helped us pick the jury.
Okay.
And they did a phenomenal job in helping us on that. And then the rest of it was Doug and I. We had kind of split it up where Doug, just to help the jury, that Doug was more dealing with the medicine aspect of proton beam therapy, the suffering of the family, and I was dealing more with the insurance trade practice issues, just so we thought that it would be easier for the jury to follow.
Mm-hmm.
I mean, there was some cross-reference in both. And then we went pretty much forward like that. We saw the case in a way the defense never saw it. I think that was easy.
You're obviously on a verdict like this, you guys see it as a big number, but are there any discussions from the defense for any resolution leading up to the case, or is it essentially a zero offer, or what's tell us a little bit about those lead-ups.
It was essentially a zero offer case.
Really? Because they just thought the 10 months isn't that big of a deal anyways, and he was going to die anyways.
He was going to die anyway.
Yeah.
Remarkably, they defended their system.
So
the health insurance industry has created like a United Healthcare system where they use these corporate policies to deny claims before they're filed. And they defended that system. And I think that stark reality of, the way I phrased it in the closing argument was these people think they're above the law. I mean, this is what the law says every insurance company has to do, whether dealing with your damage to your car. And United Healthcare is saying the people that adjust the damage to your car have a higher responsibility than people making decisions about your life. But that's what their view was. That their view of the world was, we don't have to comply with these things. I mean, some of the most compelling evidence was we took the deposition of the claims person, like the head of the pre-authorization review for Sierra Health and Life. And she had never heard of the duty of good faith and fair dealing, let alone told what had never heard of it.
Not a helpful fact for them.
Yeah, no, it's not a helpful fact. And I don't think they ever realized how powerful that sort of stuff was. And the other thing they did, which was weird, they brought in as one of their star witnesses, he was an expert from Harvard who was an economist.
Okay.
And he was a healthcare economist. And he came in to testify about how proton beam therapy is not medically necessary and basically a ripoff on the world. And
how is he doing that?
What's going on there?
I don't know. And on top of that, he had this theory about various incentives. So like patients have an incentive to get treatment they don't need because they're being tricked by doctors who are afraid that that a lawyer is going to sue him for malpractice. And we, the insurance company, are the only people who have your interests at heart and society's interests at heart. And he was like, he was
They're trying to be the plaintiff lawyers. They're trying to say, we're saving you. I mean,
it was bizarre. I mean, we fought with the judge about, his admissibility, but she disagreed with us. And
yeah, what weight of the evidence does? I mean, I just don't understand what is the purpose of his testimony.
The judge's theory is that he should be allowed to testify because he's providing evidence that utilization management is a good thing. Our counter to that is it's irrelevant whether it's good or bad. It's provided for in the contract so they can do it. I mean, none of our experts said utilization management was bad. They just said the way you see your health and life do it is inconsistent with the duty of good faith. I mean, so they put him on. I mean, it's like one of those things that, retrospect, it was one of the best things that happened to us because he was the first witness in their case in chief.
Oh.
And he was blown up because it was like, who knows more about proton beam therapy, you or Dr. Liao? I mean, do I go to, when I need proton beam therapy, do I go to you or do I go to a doctor? I mean, it was not defensible. And then he backed off quickly because we just challenged him straight up when he was, making these noises about, medical malpractice, for example. I just asked him, I said, so I'm part of the problem for increased healthcare costs. And he goes, what do you mean? I go, well, I represent people who have been injured by medical malpractice. He goes, yeah. I said, well, I guess the person who's been injured by medical malpractice, they're part of the problem. And I guess people like Sandy Eskew are part of the problem. And then he's like caught on. He's like, oh, no, I just want to be clear. That's not my position. I believe in lawsuits.
Oh,
I have no issue with lawsuits. And then we turned him and said, well, you believe in contracts, don't you? He goes, yeah. And I go, you're a free market guy. That's what you teach your people at Harvard is contracts are important for free markets, right? Why is that? Well, they provide predictability, right? People follow contracts. Yes. And that's important. Yes. And when people don't follow contracts, they should be held accountable. And so he's like,
yeah.
He didn't know. So you guys now, okay, for him and getting him flat-footed like this, then getting to really go backwards and kind of seems like he was all screwed up in his head during the trial. What's your approach to him in discovery?
Right.
How are you approaching? I assume you take his deposition on a case like this. What are you thinking? Are we saving stuff? What's the plan?
So we made a decision. Doug and I made a decision, and we didn't take any expert depots.
We're hearing this more and more, right?
We hear these big cases because it just. Matt, I want to hear your take on it. It's scary to take that position, right? Because you got a Harvard guy coming in. You're like, holy shit, what's he? But I think, and I want to hear your take is, it comes off better in front of the jury. What's they don't know what to expect from you, and you have more faith in your ability against them. Like, what's your guys' decision on that?
So with the economist, the decision was, and he was like did TED Talks, very, very engaging guy. He was totally out of his bounds at that trial, but he was a qualified economist. We thought, look, our case is insurance. That's our case. Our case is these are the rules that all insurance companies agree to follow. This is the law. They violated it, and you either going to give them a free pass or you hold them accountable. And so our view of our case was this: we were trying this as an insurance case, and so we were like, why tip our hands to any of that? The Sierra Health didn't seem to see that coming. And what are we going to get out of these guys? They're just going to, we're not going to make any points. We got their reports. I've done this in the past, and it is intimidating when you do it the first couple of times because you've never seen that expert before. You really don't know how they're gonna respond.
He could say anything.
Also,
yeah, you're not really sure what they're gonna say. I mean,
and
whatever comes out comes out. It's
that's right.
The says something, and the report says something, but if you say, well, hey, this isn't in your report, and they have a good reason why it's not in there, and it's a killer fact against you, you're kind of stuck with your pants down in front of jurors. So there's something you have to be aware of, I guess, or confident.
I think so. I mean, I think the thing is the benefit, of course, doing the deposition is you probably have a little bit more predictability going into trial, and you have an idea of what kind of witness you're dealing with. The downside is the expert now has a feeling. Maybe you do the deposition and Mike doesn't, takes them at trial, but they still kind of have a feeling of
they know where you're going.
It's going to work. And so in this case, I just kind of noticed how they were off. Like they were not ready for the cross that we were going to deliver. They weren't prepared for that cross. They weren't prepared for our case. So in this one, it worked out beautifully because they just didn't see what was going to be coming down the road. So for example, like here's one thing that ended up being a big issue to question the defense credibility. I think it was more to the defense credibility. So United Healthcare, of course, is a huge company, and they have a medical arm called Optum. United Healthcare owns Optum, and they all own all the health insurance companies. The same management company operates both. So at the same time that United Healthcare was denying Bill's claim, they were investing somewhere between $15 to $50 million to operate a proton beam therapy center in New York City.
Oh, boy,
so that's not a good fact, right?
No, that's not a good fact either. There are lots of not good facts for these guys in this case.
Yeah. Poor economists, I can hear it and be like, hey, this PBT stuff's no good, right? It's no good. Why is your client investing $15 to $50 million if they think it's so unnecessary?
And what they did, which was problematic, was that they doubled down on the concept of proton beam therapy. So they said in 2016, proton beam therapy was a scam, and it's a scam today in 2022 when we're trying this case. It's a bunch of doctors and financiers trying to make a bunch of money off the insurance company for nothing. And so once you take that position, it elevates your own hypocrisy. Like why, it wasn't like a medical debate. They presented it as a moral debate. Like we are making a morally right decision for you, an insured, to prevent you from being ripped off. And so once they make that message, it becomes a problem. And so amazingly, The Economist is one example. I just use him because he was the first witness. Nobody told him that United Healthcare operated a proton beam therapy center. Nobody. And so,
do you think the defense even knew that, though? I mean,
no, they knew about it because we disclosed it, and we brought in an expert, in our case in chief, to just link the corporate entities to show that a common management company was operating both the insurance companies and the proton beam therapy center. So we pulled it out. So they knew it was coming. Their response to a lot of it was, well, we weren't treating lung cancer, and lung cancer wasn't our focus, and the feasibility study still said this was experimental. So they had things to say. It wasn't great, but they had ways to minimize the evidence. But then when they don't tell their own experts, and their experts are sitting there saying this is a total scam. And so with Dr. Chandra, the economist, I kind of did something like, look, doctor, I think you and I, you come off as a sincere person to me. Like, oh yeah, of course I am.
Of course I am.
Yeah.
And I said,
I'm really sincere. Yeah.
I said, you have a position on proton beam therapy, and you think it's not a good therapy, and you've told us why. He said, yes. And I said, you sincerely believe that, right? Yes. And I said, you and I can have a debate outside this courtroom about the reasonableness of your position, but you sincerely believe that, right? And I said, so because you have such a sincere belief, you would never invest in a proton beam therapy center, would you? Because absolutely not. Did your counsel tell you that their sister company was operating a proton beam center in New York City, and it exploded?
So you have so my concern is on a case. Well, a couple of things I want to ask you about. Number one, I guess you assumed you were never going to be able to settle this matter because that's why you didn't take some of these guys' depositions to show them, hey, we were going to string you up or whatever. It's just, they weren't even close to discussions. So why even start doing those things?
I think that's kind of part of it. And we had kind of, I think that was part of it. And we were kind of in a collision course. This was their way of doing business.
They couldn't change it, right? They're not going to
change in midstream. And we got commitments early. Like one of the early depositions we took was of the nurse on how they process these claims, and she was so adamant about how the medical policy was what drove the claim. Mm-hmm. Her job was to make sure that claim was denied in accordance with the medical policy. Mm-hmm. Weirdly, they believed that what they were doing was okay. Nobody ever thinks about the insurer. The system was built so that no one person thinks about what the ramifications of what they're doing. Mm. So we had that testimony, and we had another piece of testimony was really effective. Was we took the deposition of the guy who wrote the denial letter, issued the denial letter, and basically he testified that we have this form letter that we generate. It's from the denial library of text, they call it, and
adverse benefit denial.
We push the button, and the denial is written, and the doctor's stamp is given, so the doctor doesn't even review or write the denial letter. And the doctor in his deposition had claimed he wrote the denial letter.
Oh man,
nothing.
Some of those things, like we had them. It's like, why fill our hand? We didn't see this
too much
to pay anything.
So then, as you're kind of thinking about everything that needs to be done, I'm thinking about this case. The jurors, this is a lot of medicine and high-level business decisions as well, I guess, and insurance bureaucracy. Like for somebody like you doing a lot of bad faith, you can wade through this and point it out. I'm a juror in Clark County or whatever, and I'm showing up for a 17-day trial or what, 14-day trial. How are you simplifying? How are you making sure they're not getting fatigued, they're staying with it, or something, they're not missing stuff? What had you done focus groups? Where were you kind of setting up the pace and the language you were using?
So we used John Campbell with the big data focus groups.
Yep.
We used him to do our focus groups, so we had a pretty good idea of defenses that could make sense to jurors, where we were a little weak, and potentially juror profiles as to what we were looking for in terms of jurors. I think the thing that was helpful, the message of the case, I think, was basically from beginning to end, we talked about insurance. Like your insurance, this is what insurance companies have to do. This is why it makes sense in the world that they do this. This is what doctors do. And what this process does is it forces the doctor to be adverse to his patient and to basically take on the role of claims adjuster as well as doctor, and the people that profit are the insurance companies. And that focus constantly, I think was helpful to the jury. And I think, frankly, you know, the medicine behind proton beam therapy it's compelling. I mean, you know, we had an expert, his name was Dr. Chang, testify about proton beam therapy versus IMRT. And I think after watching his presentation, it's like, there's no way that if I were in the same position that I'd want IMRT.
Got it.
It's just so compelling. And for Bill particularly, it was compelling because it was just right on the wall that you were exposing him to damage to his esophagus, his heart, and his lung for no reason, and except money.
Yeah,
right.
And the counter to all of that is they never brought forth the person at United Healthcare to explain why they did what they did. They had this written corporate medical policy. All their witnesses talked about it, but no one who actually developed the policy had the guts to show up in court to explain why their position was correct.
I assume you point that out in closing.
Yeah.
Yeah.
And the weird thing is I mean, it was a pretty devious way that United Healthcare developed these programs, because they kind of develop it such that nobody has personal accountability to their decisions.
Yeah.
So the people that create the corporate medical policy, they create it, but within the terms of the policy itself, there's disclaimer language that says, look, this is just a guideline. You have to look at the actual insurance contract to see whether this is covered or not. So they have, you know, no accountability, right? They're sitting there saying, well, we're not intending for this thing to be used to automatically deny claims. Now, once the policy is implemented, the corporate bureaucrats at United Healthcare developed this system where all of the employees are required to follow the corporate medical policy. So the people that are sending out these denial letters, it's like, hey, we're just doing what the company told us to do. Corporate medical policy says it's not medically necessary. Who do we to question? So they're not accountable for their decision. So it's like this whole system of people that don't know the impact of what their decisions are making. And the other thing that they do is they include appeal provision within the terms of the insurance policy. It's not mandatory, but they provide the right to appeal. And Bill did not pursue that right because he relied upon his doctor to say, look, you really don't have, you're risking your life if you take the time with the appeal.
Yeah.
Terrible.
But
terrible
that became
choice.
a big issue for the defense, because they wanted to imply that Dr. Liao didn't believe in her position, or she would have told her to appeal. And so the evidence that then came out at trial was virtually, it's like less than 1% of any denied claim is reversed on appeal. It's like a built-in system
Of losing.
Our expert called it, our insurance expert, Steve Prater, called it, that what they want is a free denial.
Mm-hmm.
They deny the claim and then they want to go to appeal. And the fact is the appeal is a sham. But that was an issue. We kind of eliminated that issue when we asked the managed care expert on the stand. He kept talking about the appeal. And I'm like, what does the appeal have to do with anything in this case? And he's, well, you know, blah, blah, blah. Yeah, would have filed it. Or I said, well, can we agree with this proposition that an insurance company doesn't get a chance to deny a legitimate claim twice? And he's like, well, I guess so. And I said, so you would agree with me that if you didn't follow the rules, they didn't follow the contract, when they denied this claim, the appeal is irrelevant. And he said, I agree with that.
Okay.
So it kind of like put it away. And it actually became a part of our case for oppression, because like, who does this? Like, why would you not do your full investigation up front, then if you have to deny the claim, disclose the basis for the denial and then make an appeal system that's actually reasonable. It's just a way of placing the insured in a position of having to make lifetime medical decisions based upon how their insurance company is going to follow the contract. And so, I think all of those things just empowered the jury to understand how important this case was to Nevada. I mean, this was like the testimony in this case was that the procedures that Sierra Health and Life was advocating as reasonable and acceptable to insurers impacted every insured in the state of Nevada. That's what their expert testified to. And he testified, and beyond that, it impacts every insured across the country. And he's there's like 400 million people, or that wouldn't be that much, but like 50 million people. It's like this huge number that he created. And
he's spreading those tentacles for you.
Yeah, I mean, right. So the process is not like, and it was like they built in the importance of this case.
Yeah,
the way they defended the system. I mean,
the ultimate system failure, I guess, because they built the system this way.
It's like a product liability case. Their system was defective, and they knew it, and they just kept using it. So they knew the risk that they were creating.
So I know we're getting short on time, but I am curious because you're looking at this case. It's a 40 million compensatory and 160 million punitive.
Yeah.
How did you arrive at those numbers? Did you rely on some John Campbell work? Was there a gut feeling going in? Was it a combination of both? What were your thoughts?
Well, it's probably a combination of everything. I mean, there were things, I won't get into the detail, but we had talked to the jury in voir dire about numbers and about what would be reasonable for something like this. And basically through the course of trial, it kind of became a mantra on our part that we were going to ask for somewhere between 15 to 50 million in compensatory damages. Defense took hold of that to try and say these are a bunch of greedy lawyers trying to milk the system. So I think that anchored that this was and it was a really important case, right? Mm-hmm. And this guy really suffered. And so those things together, that's how we came up with what we were going to ask for the jury. And I think what the jury saw was just the idea of how this man suffered. I mean, it really is kind of like the old Mo Levine thing, it's not what you took, it's what you left the plaintiff with. And that kind of was our mantra on damages. They left this man with nothing at the end of his life. So that's how we came to the 40. We didn't have any
for 40 and they gave you 40.
We asked for 30 to 50. They gave us 40.
Perfect. And then punitive.
Yeah, I mean, that's what's that?
Did you go right into the punitive phase, like right afterwards, or is there a next day you start a punitive phase?
Yeah.
And what'd you ask for there? Do you have a number you tied it to?
We asked for 160 million. We told them we tied it in to what we thought would be a reasonable Campbell factor.
Got it.
On appeal, given the extent of wrongdoing, and they kind of helped us along the road because they put up one of their witnesses to say, now we're going to teach everybody about the duty of good faith and fair dealing. We don't think we did anything wrong, but now we're going to say, and then they also took the position that, now if this claim were handled, we would have a radiation oncologist evaluate the claim. So for 3 weeks, they were claiming an oncologist.
And then punitive, they changed their position.
In punitives, they changed their minds. They even suggested in closing argument that had the claim been presented today, it would have resulted in the claim being accepted. I mean, they
try to do totally different. It always it boggles my mind when they do that. They're like, well, it's like, wait, you just spent the whole trial doing the total opposite. Now you come here and you're like, we're really sorry. We're a small little company. We didn't, your statement has been made, blah, blah, blah.
Yeah. I think I think they do it for appeal, hoping that some justice, Supreme Court justice in our state, Supreme Court justice, will look at it and say, oh, well, they have a mitigating, there was mitigating factors. I mean, it's like, I can't explain any other reason why they went in and did what they did after saying everything they did was great. One of the final witness they brought into their case in chief was a nice African-American lady. She was a nice person. She was a person who didn't know anything about the duty of good faith and fair dealing. Wow. And she basically came in to try and give a face to the company, and, they try and help people. And on the cross-exam, I just said, I just want to know where we stand. I mean, this is what so-and-so said they did, and this is what they did do on handling Bill Eskew's claim. And you're saying that from United Healthcare's perspective, as your title, that's entirely acceptable to you now and into the future. And I just went through the elements of the case. I said, I just want to know this. And everyone says, yes, now and into the future. So the jury they saw the importance of what they were faced with, to make a statement and a decision that, had impact for people. I hope it has impact for people,
Clearly at that amount. That's a tremendous, I'll be open with you. I didn't know what to expect. I had read a little bit about the case. But I mean, the level of detail and the curiosity that you guys had to kind of delve through this, this case is very, very interesting. And, congratulations on an incredible result. I know probably a million people have told you that, but this is a great, it's like a paramount type case, and it really does probably change corporate behavior. And there's not many of those. There's not many opportunities to do that. And it seems like you guys really have done that. So congrats to you guys. That's fantastic. I mean, what a story.
Yeah, it was. And, we're lucky to have had, somebody like Sandy Eskew, willing to fight. I mean, most, and they, they insulted her, they insulted her family.
Clearly she's got it, because I mean, just the way that you described her, I know that he had been diagnosed in 2015, and then they got this policy in 16, I think. Is that kind of how it went? And so she had done who reads a policy? She had done all the diligence they had done. And I guess that's one of the things you guys could point to is like Sandy and Bill did everything they possibly could. They literally did everything they could do. And they trusted this company they bought a policy from. And it totally it's not like they added something late. They were up front, they got it all, and they got screwed.
And I think it was beyond that, because, that it's kind of, it's akin to a consortium issue, because, the damage to one is damage to both, right? So it was more Bill not only seeing that his doctor had been overruled by a piece of paper or by some Dr. Ahmad. He didn't know that, obviously, the whole scam that was going on. That's bad enough, but to have effectively, in his mind, they lied to his wife.
Yeah. Big deal. Yeah.
Well, I mean, look,
so
I can't, I can't echo Chris's sentiments enough. I mean, first of all, it sounds like he had a great client, but more importantly, she had great lawyers. And you guys, like Chris said, this is paramount. This will change corporate behavior. And thanks for fighting the good fight, man.
Yeah, thank you. I mean, it was an honor for Doug and I to be involved in this case.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. Here's your hosts, Mike Campbell and Chris Finney.
Powerful stuff.
I hope people followed it, because there were so many things going on with that case, and just really how they got into that stuff and kind of broke it down, and strategy decisions that he made. Selfishly, I learned a lot there. And then unfortunately for everybody else, we had probably a 15-minute discussion that we probably should have recorded. But we were still talking about how they instructed the jury, what they did. I mean, it was the guy's a wealth of knowledge. You can clearly tell, speaking to him, he knows a lot He's very experienced, and he gets way into the cases and is going all the way on them. It's impressive.
Yeah, I think it's one of those things, and we did, and so we tend to do that. We talk afterwards with whoever's on, and it's like, oh man, we could go for hours and hours on this stuff. Want to respect everybody's time, but when it comes to someone like Matt, you know, he gets it. And I mean, that's like I think like the highest compliment that someone could get is like, oh, this guy gets it. He's on the same. He is head and shoulders above where I'm at as a lawyer, and so that's why I'm so glad to have him on to talk about this stuff, because it's like, man, this is just
like I would describe him as the perfect combination of like high level intelligence and approachability.
That's right.
Like it was like, oh, this is complex stuff, but he like, I was understand. If I can understand it, most jurors are going to be able to understand it. That's like, right. I'm on that wavelength, and nothing against the jurors, but like that's it wasn't really exactly blowing the law school professors away.
I'm aiming for like mid to low level intelligence, and then also like semi approachability, but also like enough awkwardness that people know just to not talk to me, you know. So we're almost there. I'm like,
you're almost there. You've almost completed it.
Yeah, I'm that perfect balance of when people come up and talk to me, and I'm like, I'm sorry, I'm awkward. I'm awkward, yeah. You know, like, I'm sorry, you know, and like, I love doing that, but yeah, the guy's is great. Loved having him on, and on to the next one.
That concludes another episode of Case Autopsy, the Verdict and Settlement Podcast. Part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.